Case 65. Stethem versus Islamic Republic of Iran. Warning: this may be disturbing. We find ourselves at the U.S. District Court for the D.C. Circuit. Facts. On the morning of Friday, June 14, 1985, TWA Flight 847, a Boeing 727, took off from Athens, Greece, bound for Rome, Italy, with a full complement of 143 passengers and a crew of 8. On board were U.S. citizens Robert Stethem, Kurt Carlson, Stuart Dahl, Jeffrey Ingalls, Clinton Suggs, Tony Watson, and Kenneth Bowen. All were U.S. military personnel en route back to the U.S. from various assignments abroad, and coincidentally aboard the same plane, traveling in civilian dress. Shortly after takeoff, the plane was commandeered at gunpoint by at least 2 hijackers, also armed with hand grenades, who forced the plane to divert first to a landing for fuel in Beirut, then on to Algiers, and back once more to Beirut, finally landing dramatically at night in Beirut about 16 hours after the flight had commenced. During the journey, several of the servicemen were brutally beaten by their captors. Robert Stethem, a 23-year-old U.S. Navy petty officer, trained as a diver and underwater construction specialist, was executed by gunshot to the head, and his body shoved from the plane onto the tarmac at the Beirut airport. Eventually debarked from the plane as prisoners of a local militia in Beirut, the surviving servicemen were held captive by Confederates of the hijackers until June 30th, 1985, when they were released to Syrian military personnel and ultimately flown home. The airborne portion of their ordeal was characterized for some of them by excruciating pain from repeated beatings, and for all of them by stark terror in expectation of either an imminent violent death or prolonged captivity. While imprisoned in Beirut, they were confined under execrable conditions, tormented with daily threats of torture and death, and vilified as citizens of a despised nation, all the while uncertain of their fate. These 2 consolidated actions by the servicemen and their spouses, and by the personal representatives of the murder victim, seek to recover damages from the parties they hold ultimately responsible for these terrorist acts: the Islamic Republic of Iran and its Ministry of Information and Security, pursuant to the Foreign Service Immunities Act. Defaults were taken against defendants, meaning defendants didn't show up to court, in both cases, on December and June, respectively, and upon the evidence adduced at an ex parte hearing before the court in October, which the court finds to be satisfactory for the purpose, the foregoing and following facts are found pursuant to federal rules of civil procedure. Judgments will consequently be entered for plaintiffs in accordance with the conclusions of law drawn therefrom. The hijackers, known only by the sobriquets Crazy and Hitler by the TWA passengers at the time, have been reliably identified as belonging to Hezbollah, a radical Shiite paramilitary organization recruited, trained, and financially supported by the Ministry of Information and Security of the Islamic Republic of Iran. Originally affiliated with Amal, the Lebanese militia supported by Syria during the Lebanese Civil War, and a frequent collaborator with Amal even after shifting allegiance to Iran following the Israeli invasion of Lebanon in 1982, Hezbollah has been implicated in numerous acts of terrorism, for which this district court has held its patron state, Iran, liable under the FSIA. So what's the issue? Whether the defendants were responsible for the hijacking of TWA Flight 847 and the attendant hostage-taking and torture of the plaintiff hostages, and what amounts of damages are each of the parties entitled to. Holding. The court held the defendants responsible for the hijacking of TWA 847 and the attendant hostage-taking and torture of the plaintiff hostages. The court awarded the Stethem parents $5 million each and the Stethem siblings $3 million each for the loss of Robert's society and companionship. The court awarded Kurt Carlson and Clinton Suggs $1.5 million each, and Stuart Dahl, Jeffrey Ingalls, Tony Watson, and Kenneth Bowen $1 million apiece for injuries suffered at the hands of the agents of the defendants. The court concluded that the spouses of Kurt Carlson, Stuart Dahl, Jeffrey Ingalls, Clinton Suggs, Tony Watson, and Kenneth Bowen were entitled to damages for loss of consortium and solatium and were awarded $200,000 each. The court assessed punitive damages in the amount of $300 million against the MOIS to be awarded to all plaintiffs, jointly and severally. It was further ordered that plaintiffs may arrange for this decision and order to be translated into Farsi, and at plaintiff's request, the clerk's office shall cause a copy of the translated decision and order to be transmitted to the U.S. Department of State for service upon defendants through diplomatic channels. Let's define sovereign immunity. A government's immunity from being sued in its own courts without its consent. The concept of sovereign immunity dates to the ancient common law maxim Rex non potest peccare, the king can do no wrong, pursuant to which English subjects were barred from commencing or prosecuting suit against the monarch or his agents. This concept, encompassed in the doctrine of sovereign immunity, was in part enshrined by the 11th Amendment of the Constitution, which renders the United States, its departments, and its employees in their official capacities as agents of the federal government immune from suit, except as the United States consents to be sued. FSIA. The FSIA addresses the circumstance of suing a foreign country in the U.S. It is jurisdictional in nature, therefore. The Foreign Sovereign Immunities Act of '76 is a U.S. law codified at Title 28 of the U.S. Code that establishes the limitations as to whether a foreign sovereign nation may be sued in U.S. courts, federal or state. It also establishes specific procedures for service of process, attachment of property, and execution of judgment in proceedings against a foreign state. The FSIA provides the exclusive basis and means to bring a lawsuit against a foreign sovereign in the U.S. While a foreign state is generally immune from the jurisdiction of the courts of the U.S. under FSIA, the plaintiff sued the defendants pursuant to Section 1605. That section explicitly authorizes, as an exception to the general grant of sovereign immunity, suits against foreign nations that sponsor terrorism for certain acts that cause personal injury or death, if either the claimant or victim was a citizen of the U.S. at the time. The FSIA imposes two preconditions. Number one, the foreign state must have been designated as state sponsor of terrorism at the time of the acts, and a plaintiff, either claimant or victim, must have been a U.S. citizen.